worked out well. We're ready for a little break. We've all been stuck in traffic, so ready for our next case.
Roger Baskin versus Pearson Alred Construction, Inc.
Afternoon, Your Honors. I'm Charles Michaels, and I represent the appellate, Pearson Alred Construction Incorporated. I'd like to reserve 15 minutes for rebuttal. This case originates out of the Davidson County Chancery Court. It involves a contract entered into between Pierce and Roger Baskin, who is a Tennessee resident, to construct a home in Muscle Shoals, Alabama. The trial court dismissed the case for lack of personal jurisdiction, and the Court of Appeals overturned the decision. There are three issues. Pierce admits there's three issues for the court to decide in this case. First is whether Pierce's contacts with Tennessee that solely relate to the Baskin project are sufficient to confer personal jurisdiction over Pierce. Second, or whether Pierce's contacts with Tennessee that arose after Baskin's, or after its alleged breach of contract with Baskin are relevant to determining whether Pierce is subject to personal jurisdiction in Tennessee. And third is if those after acquired contacts are relevant, whether Tennessee should look to the time of the cause of action arose in determining minimum contacts, or should look to the time when the plaintiff files suit. Pierce admits that as to the first issue, Baskin was Pierce's only connection to the state of Tennessee at the time that the contract between the two was entered. Pierce was a Tennessee resident. He hired Pierce to build the home in Alabama. The contract was signed in Alabama. The contract only contemplated work in the state of Alabama, the construction of the home. And Pierce was incorporated in Alabama and was doing business there and used Alabama subcontractors, and had only performed one other job in Tennessee before, which was marginally construction work, as it involved moving a log cabin from Nashville to Alabama. The first issue touches on this court's 2020 decision in Crouch v. LS Energy Fabrication. As I'm sure you're all aware, in that case, the defendant, the defendant was a Texas company. It had entered into a contract with a Tennessee company for design and consulting services related to a railway repair facility. The Tennessee company, I believe, did initiate the negotiations for the contract. But the real issue there was that the bulk of the contract, or all of the contract, was going to be performed in the state of Tennessee. That's where the design services were going to be rendered, and that's where the Texas company was going to have to communicate with the Tennessee company in order for those plans and the consulting to go.
But the project itself was in Texas, correct?
The ultimate facility would have been built in Texas, is what I understand from the case. And looking at that specific issue, with the project itself being in Tennessee, the design, when the two parties were entering into that contract, I believe the court was looking at it from that perspective, in that the parties contemplated that the design was going to be done in Tennessee. The parties, through their actual course of dealing, the action was done in Tennessee. And one other issue with that is if there wasn't necessarily anything to do in Texas, that company could have, highly unlikely, but they could have decided to go to Oklahoma and build the same rail car facility with the same design, and it wouldn't have affected any of the Tennessee company's obligations. They still would have been performing the design services and the consulting services in the state of Tennessee. And I know the Court of Appeals viewed the facts in this case as similar to Crouch. Pierce respectfully disagrees. In this case, when the parties entered into the contract to build the home in Muscle Shoals, Alabama, the only work that was going to be performed was in Muscle Shoals, Alabama. There wasn't anything in the contract that required Pierce to use a Tennessee design firm. There wasn't anything in the contract for Pierce to use supplies from Tennessee. And there wasn't anything in the contract that required Pierce to send invoices to Tennessee because, of course, Baskin could have moved to any number of states, Georgia, Mississippi, and Pierce would have been sending those invoices to those states instead of the state of Tennessee. And that's the same issue with the design, the plans for the home that were from a Nashville company, as well as the materials that Baskin sourced from Tennessee. Baskin could have sourced those materials, again, from any state that he wanted to, and Pierce would have incorporated into the project. And Baskin could have hired a design firm from any state that he wanted to. And again, Pierce would have used those plans. There was nothing that required Pierce to do any sort of continued business with the state of Tennessee under the contract.
But really, the inquiry is not really whether they were required to, it's whether they did or did not, isn't it? I mean, the fact that they could have gone somewhere else doesn't really have any bearing on the fact of what were the actual minimum contacts of the defendant with the state of Tennessee here. Now, I take your point that there is some real question about that, but the fact that it could have been done somewhere else is not really a relevant inquiry, is it?
To an extent, courts have suggested that the plaintiff's unilateral actions will not confer jurisdiction. I understand.
Well, unilateral actions are
Yeah.
different than hypothetical actions.
Correct, yeah. I understand that Baskin did remain in Tennessee, and that's where he did supply the design firm and those.
What contacts do you admit that were with Tennessee by your client?
I apologize, can you repeat the question?
What contacts what are the contacts you view your client had with Tennessee?
Certainly that Baskin was a Tennessee resident. To the extent that Baskin was providing the design firm from Nashville, and Baskin again could have provided that design firm from anywhere, I agree that it's a contact with the state of Tennessee that Pierce used those plans. Whether it's ultimately a relevant contact, given that, again, the firm could have come from anywhere, is another question.
But the design work was done in Tennessee.
The design work would have been done in Tennessee.
Okay.
And off the top of my head, it may have been completed before the project began, which, again, that's another functional difference between this case and Crouch, where the design work was the basis for the contract. Here, the design work was, I believe, already done. I presume it was already done, given that the contract here was a contract to build a home.
Your client did not participate in the design plans, correct?
No, I don't believe so. At the outset, there may have been some discussions with the design firm as the project went along due to potential changes requested by Baskin. But as to the general design of the home at the outset, no, my client would not have been involved.
Was Baskin in Tennessee during some of the communications between?
Yes.
Okay, what were the nature of those communications?
My understanding, again, is that the communications were related to the project being done in Alabama, the status. I know there was an issue with some items that were left out and exposed to the elements that were damaged. I know there were some changes to the plans as the construction went along, and assumably there were discussions related to payments from Pierce to Alabama to Baskin, or from Baskin to Pierce in Alabama. So again, yes, those are contacts with the state of Tennessee to the extent they are relevant in determining, or to the extent that they would lean towards conferring personal jurisdiction over Pierce. Again, I would say they do not, because it's, again, Baskin's actions that cause the connection to Tennessee, not Pierce's actions.
So go back to Justice Bivens' question. What contacts do you say your client had with Tennessee? A Tennessee resident. Okay, what else?
He certainly communicated with Baskin, who was in Tennessee. And again, he did build the building pursuant to a design from a Nashville company, and as I understand, there was some communication with the Nashville firm during the construction. And he did use supplies that Roger Baskin provided from the state of Tennessee. That's where he sourced them from. Baskin chose those items. He paid for them up front, I believe, and then Pierce did charge a contractor's markup when he received the items.
Where was the injury?
The physical construction itself was the injury, in the sense that you look at an injury like a car crash. Now, where the injury and damages were felt would be considered Tennessee, because that's where Roger Baskin is or was, and that's where the monetary damages were caused. On the other hand, Baskin was going to have to spend money to finalize the construction project in Alabama with a different contractor. So to the extent he was damaged in Tennessee monetarily, he was still going to have to spend that money in the state of Alabama. And again, there were the other injuries that were in Alabama would have been, there's, I think, $6,000 in damages to audio equipment that were left out to the elements. Obviously, the defective workmanship. And Baskin alleged that he incurred approximately 3 years of storage costs for one reason or another, due to Pierce not completing the project on time.
When do you say the plaintiff's cause of action accrued?
In this case, just looking solely at the plaintiff's complaint, it was alleged that Pierce breached the contract with Baskin by not completing the project on time. The only date in the complaint itself for completion was January of 2018. Baskin also alleges that Pierce caused the $6,000 in the audio equipment, and he alleges that was for 3 years, and based off when the complaint was filed in September 2020, that would go back to September of 2017. And then and there was a point raised by Baskin in its brief before this court about waiver of the failure to complete on time in a home residential construction action. Pierce would submit that it's difficult to argue waiver here when the face of the complaint says that the project wasn't completed in a timely manner.
There is no choice of law or forum selection clause provision at issue here, correct?
There's no forum selection clause, and there is no choice of law clause to the extent the law of Alabama or Tennessee would be applied. I presume even if this case remained in Tennessee, it would be Alabama law, because there's a Tennessee statute that says if the work is to be done in Tennessee, then a choice of law clause that selects the law of another state is unenforceable. So for public policy reasons, I assume Tennessee would not apply Tennessee law to an Alabama project.
If I recall the Court of Appeals decision correctly, that court said that the contacts in this case are more than in the Crouch case, right?
That's correct, Your Honor.
Why do you disagree with that?
Again, in reviewing Crouch, the contract was going to be performed in Tennessee. That's where the design was being done at. That's where the parties had contemplated that the consulting work would be done at in the future. And in this case, all the work was contemplated to be done in Alabama, and there was no way for Pierce to do the work anywhere else, because he was building a home in Alabama. And that is how I would distinguish the Crouch case.
These cases have always been hard for me, going back to the first time I read International Shoe. I mean, the courts just cite the contacts, and then here's my answer, and sometimes it depends on who's looking at it. In this case, we've had one judge look at it and say not enough, and another 3-judge panel said yes, There is enough.
And interestingly enough, the judge has said not enough did cite to, he did say the contacts were not sufficiently related, those being the after acquired contacts in Tennessee by Pierce, to use those contacts to confer personal jurisdiction over Pierce, which became an issue on appeal once the Ford decision was handed down. It was actually in the trial court level, Baskin only argued as to specific jurisdiction that Pierce's contacts with, or Pierce's contacts with Baskin mattered.
Okay, thank you.
Good afternoon, Your Honors. May it please the court. My name is Paul Krogh, and I represent the respondent here, Roger Baskin. Tennessee courts can exercise personal jurisdiction over foreign defendants who purposely avail themselves of the benefits of Tennessee markets. And as the court knows, that's true whether the foreign defendant comes looking for a Tennessean from whom to purchase goods and services, or to whom to sell its own goods and services. Here we have the latter, obviously an out-of-state defendant who looks to Tennessee to sell its custom home building services. And that custom home building service it offers in Alabama, and also offers it subsequently to the events here in Tennessee. But we actually have two instances in the record where the defendant sells those Alabama-based services in the Tennessee market. It sells those services to Mr. Baskin in an agreement it signs in October of 2016. And the record's very clear, and this is highlighted in our brief, that it also has an agreement with a gentleman from Nashville by the name of Will Andrews in August of 2016 to build a house on the same lake in Alabama. And Mr. Andrews.
How many are enough? I mean, what's your position? Is once enough? Is twice enough? I mean, what's the threshold for purposeful availment?
For this kind of, especially for this kind of contract, Your Honor, one is enough. Because each of these custom home building contracts hits all the points that Crouch and Burger King make relevant. And obviously, Burger King is one transaction. It's one franchise agreement. Crouch is one transaction. It's one consulting agreement. And the consulting agreement in Crouch is a lot like the agreement we have here. This isn't a...
Well, let's explore that for a second.
Of course, Your Honor.
In Crouch, the design work was performed by the plaintiff in Tennessee.
Yes.
Correct?
It was,
All right. And here, the crux of the work is being done in Alabama.
Of course.
And the plaintiff contacted the defendant, correct, initially.
Yes, Your Honor.
The plaintiff provided the plans to the defendant without at least the initial input of the defendant. The plaintiff provided the materials to the defendant in Alabama, right?
Some of them, yes, Your Honor.
So isn't that the actions of the plaintiff instead of the defendant? And if that's the case, how does this case have more significant contacts with Tennessee than Crouch? I have trouble with that.
Well, Your Honor, most of the points that Your Honor just identified, Justice Bivens, are ones that this court in Crouch Railway Consulting said didn't matter very much. The fact that the plaintiff performed the consulting services in Tennessee in Crouch was specifically highlighted by the court as not particularly weighty. What mattered was that the parties had this involved relationship that entailed intercourse between them, communications back and forth, money, emails, letters.
Relating to the activities that were conducted in Tennessee.
Relating to the activities conducted in Tennessee. But there are lots of cases where the activity, we have that same kind of back and forth relationship, and the activities take place elsewhere. There was a 1994 case from the Court of Appeals, the Southland Express case, that's cited in our brief, where the parties' entire relationship was scrap hauling, and the Tennessee party called up the Florida party and said, hey, I've got scrap. The scrap is in some other state. Can y'all go pick that up for us? And because they had a continuing relationship where they did this on an ongoing basis, and that's a fairly straightforward, uninvolved type of relationship.
But isn't that distinguishable in that it was a continuing, ongoing relationship? I'm actually not familiar with that case, but were there kind of multiple contracts, or at least a contract with, an ongoing series of scrap hauling activities? Is that right? And that's not what we have here. I mean, this was a contract for one home.
We have one long contract instead of multiple small contracts. The same as you had in Crouch. I think that was that a 6-month contract in Crouch. This is a contract that contemplated over a year of work, and whereas the defendant admits, you had ongoing communications back and forth. It's a custom house, right? And the reason there's for instance, no forum selection clause or choice of law clause in this case is that the contract is really just a proposal. And it's very bare bones. And for this sort of work, the parties have to be in constant communication throughout the process to make it work. What dishwasher are we going to install? What size drywall are we going to hang? Approve these finishes.
But Justice Bivens' point was that all of this work took place in Alabama, and the converse of that was true in Crouch. You're not really saying that doesn't make any difference, are you?
I think the court said that it wasn't terribly important. It is a distinction, right? The work takes place in Alabama, and so if we didn't have the intercourse between the states, right? If Mr.
Come on, isn't that a very significant difference? All the work took place outside of Tennessee.
The work took place outside Tennessee, Your Honor, but it took place in the context of this relationship that involved a relationship between the states.
Suppose that during the course of this construction, Baskin had just up and moved to, let's say, Texas. A lot of people are moving to Texas these days. So Baskin just up and moved. Project continued on in Alabama, but the communications then shifted. So invoices started going to Texas. Communications about the project were now occurring between Texas and Alabama instead of with Tennessee. Is personal jurisdiction now proper in a Texas court?
That would be a much harder case, and I'm not sure the answer is yes. The answer very well might be no. I think
Why is that a harder case?
That's a harder case because the defendant didn't, at the outset, form a relationship, enter into an agreement that contemplated this ongoing relationship with a Texan, right? He contracted to build a house. Presumably the contract doesn't have a unless you move to Texas clause. And
well, there's also nothing in the contract saying that, that Baskin's going to remain in Tennessee and all of the communications will take place in Tennessee. I mean, it was just happenstance that he lived in Tennessee at the time the contract was entered into for activities that would occur completely in Alabama.
The same is true in Burger King, Your Honor. Burger King could have moved to Texas. Burger King could have moved to Texas, right? John Rudovich and Burger King signed a franchise agreement that contemplated that the franchisee was going to do all of his work in Michigan. And in fact, he dealt mostly with local contacts in Michigan. But Burger King itself was in Florida, and it had the final say, and it did everything that, it did all of its work on its side in Michigan. But most of that's a relationship centered in, I think I said that backwards. Burger King did its part in Florida. Most of what was contemplated by that agreement, though, was him running a Burger King restaurant in Michigan. And Burger King, conceivably, right, could have moved at any time to another jurisdiction. The courts haven't regarded the raw possibility that one party could move as sufficient to defeat the other party's intention to form a relationship with the forum by entering into a long-term agreement with the forum resident.
I mean, my recollection of Burger King is that there were parts of the agreement that specifically contemplated some activities occurring in Florida. Training requirements, for example, that would take place in Florida. So it wasn't, I think that there was a little bit more going on in Burger King to suggest that the parties actually contemplated activities being performed under the contract or related to the contract that would take place in that state.
That's true, Your Honor. There were a few points where the contract specifically contemplated things that one of the parties or the other had to do in Florida.
Was there anything here that had to take place in Tennessee?
Well, payment, right? And again, I think the point with Burger King is, again, the contract said that you have to come do our training. I'm not sure the court said that it required Burger King to stay in Florida to provide that training, right? If Burger King had moved to Texas, would Mr. Vudovich have been able to say, well, I don't have to come to the training now, which apparently he never did anyways. I think his partner did. But here, obviously, Pierce and Alred builds a house. They send invoices to Tennessee. They know they're being sent to Tennessee. They expect those to be paid from a person in Tennessee. And the fact that the person...
Well, they just expected them to be paid. I mean, they didn't really care. I don't think they would have rejected a check that came from somewhere other than Tennessee.
Well, no, but I've certainly never seen a case. The defendant has never cited a case that suggests that when you invoice a forum resident, that doesn't reflect an intention to cause the effect of payment from within the forum. That's the case law says exactly the opposite. That if when you...
So is it...
No, go ahead.
Sorry. Well, so is it your position that is receiving payment for one contract, one time with a resident of a state is sufficient to give a court in that state personal jurisdiction over the defendant?
I think the case law says the answer to that question without any additional facts is no. If I buy if I buy something that's a prefabricated good, right, and I have one isolated transaction that's a just buy and sell of a fungible item, then I think that is what the case law calls, random or attenuated or isolated.
So what pushes this across the line then?
I think what pushes this across the line is we have this involved long-term services contract like we had in Crouch.
But again, the services in Crouch were being provided in Tennessee. The services in this case were being provided in Alabama. That's a big distinction. And you keep saying that the Crouch court talked about the activity, the design work being done in Tennessee was not a big deal. Actually, it was the communications back and forth that were not the big deal in that case. The design work was a very substantial factor in that case.
I'm not quite sure how we can place so much importance on payment in the current day and age. I mean, we're not operating in an environment now where somebody mails a physical bill and they get back a physical check. Everything takes place in a different context. So how can we place that kind of emphasis on the fact that the person who's doing the payment is located in Tennessee when the payment takes place virtually and without a location essentially. So I'm not sure how we can place that much emphasis on that, and I'd like you to address that.
Well, certainly every time the courts wrangle with this, they have to address, they're dealing with these sorts of problems. The fact that it is continually becoming easier to communicate between states, and the methods of communication are becoming more ephemeral. And yet, it would be incongruous to say that it becomes less fair to require a party to defend a suit in a foreign jurisdiction because it is easier to transact business across state lines.
Why is that less fair? There's just less attachment to Tennessee in that situation, it seems. And less again, Justice Campbell made the purposeful availment point. Very little of what you're talking about sounds like purposeful availment.
I think Justice Kirby, Pearson Allred certainly purposely availed itself of the availability of people who want large custom homes in Middle Tennessee. The same way that Ford Motor Company purposely availed itself of people who might want Fords in Montana. Or
So two contacts in Tennessee is the equivalent of Ford spending millions of dollars to advertise and promote the same type of vehicles that were used in the case involved in the Ford versus Montana case. That's an equivalent context?
they're not the same, Your Honor, but we're dealing with a business that only does 6 projects at a time. So context matters. We aren't going to have a personal jurisdiction regimen that only applies to large international manufacturers.
Here's the problem I'm having. I mean, you have acknowledged that it's clear, under Burger King, that a single contract for the purchase of goods or services with a resident in a particular state is not in and of itself sufficient to give a court in that state personal jurisdiction.
Not necessarily.
Okay, so you don't acknowledge that.
I mean, it depends on the services. I mean, there are cases that we cited in our brief that are where you have one transaction that does confer jurisdiction if it's a material enough transaction,
But it's not the transaction itself that necessarily creates personal jurisdiction. It's maybe something about the transaction or the contract that contemplates some sort of future contact with that state, ongoing contacts or an ongoing relationship with that state. Am I understanding you correctly?
or contacts that take place in the context of the transaction. Yes.
So give me
yes,
an
Your Honor.
example of something like that.
Well, I think there's one of the cases we cited was a case in which you had one license agreement for intellectual property, and the out-of-state defendant entered into one license agreement and then sent 3, 4, 5, exchanged a small handful of communications about that same agreement. It's not necessarily that the license agreement contemplated an ongoing intercourse, but that there was some intercourse related to it and surrounding it.
But where did the activities related to the licensing agreement take place? In the forum state?
I think in that particular context, I don't recall where.
I mean, I guess I keep coming back to the point that Justice Bivens has been making, or the distinction that Justice Bivens has been making between this case and Crouch, which is that the activities being performed under the contract were wholly outside of Tennessee in this case, which is a significant distinction from Crouch. Do you agree with, let me ask you this. I guess the Court of Appeals found the contacts in this case to be more substantial than the contacts in Crouch. Do you agree with that?
I do, Your Honor, because I think Justice Bivens doesn't.
Pretty well said that. That's right.
But because the Court of Appeals made clear that in Crouch, there wasn't a ton of back and forth. It was a big project here, but of course,
There wasn't a ton of back and forth here, though.
there wasn't a ton of back and forth here. But the defendant testified that he made there were repeated communications, and they were substantive. And here's the problem, I think, with trying to make Crouch turn on what on the consulting services here, is that those were the plaintiff's work. And so if you make it turn there, then you do have a situation in which the plaintiff can generate his own jurisdiction, right? If I do a lot of work, then I get jurisdiction. But if we shrugged it off and didn't do anything, well, then we wouldn't. But that's not how the courts say the test works. The test has to look at what the defendant did, and the defendant is out of state.
But what the plaintiff did in Crouch was specifically related to the contract that was at issue, and the defendant in that case knew what the contract provided. It wasn't make work done by the plaintiff in Tennessee. It was the specific requirements of the contract. So if the defendant's expectations are created by the contract and the plaintiff is then simply performing the duties in Tennessee with the full knowledge of the defendant, isn't that a big difference?
It is certainly a material, factual difference between this case and that case. I haven't seen, I don't think the defendant has pointed to, a case that says that should be the determining factor, though. I mean, yes, it's clearly a factual distinction, but it's a factual distinction that doesn't appear to take a lot of prominence in the case law. And it would make many other cases odd, not just the Southland case, but there's a line of hotel cases, for instance, that some of which are cited in our brief, and one of which is cited in the Voss Company case out of the California Supreme Court from 1994, which is cited in our brief. And there's a line of these cases where a out-of-state hotel advertises to the forum, a forum resident comes to the hotel and is injured, shower bar breaks, something like that happens, he slips on the floor. And the forum resident is able to successfully sue the hotel in the forum because of the essentially advertising relationship that the hotel formed by soliciting them. Now, nothing the hotel did related to the claim took place in Tennessee. And that brings, I think, back to Ford. To say that what you have to have is the key activities. If the key activities have to take place in the forum, then you're back to a causation test for relatedness. And Ford Motor Company tells us that that's not the test. Right? If the contacts had to cause the claim, then Justice Bivens, I think the point about where the service is performed would become very important. It would take center stage, because how can a claim arising out of a services contract not arise where the services are performed? But if we take a step back and have a different test for relatedness, then we don't have to have the services in the forum. We can have the services out of the forum as long as we have the kind of relationship between the two states that those kind of services contemplate and require. And that's what you see in a lot of the cases, especially the cases from jurisdictions that weren't requiring strict causation tests for relatedness. And just to come full circle, O'Connor versus Sandy Lane Hotel Company, which is cited in our brief, and Nowak versus Tack Howe Investments, 94 F. 3rd 708, 96 First Circuit. Those are two of those hotel cases with the out-of-state hotel injury. And it's about relationships. The Supreme Court, all the way back in 1950, in the Travelers Health Association case, said that continuing relationships between forum residents and out-of-state defendants can give rise to minimum contacts. And here we have a continuing relationship. We also have the contacts before and after the commencement of the work on Mr. Baskin's house. And all of those are related to Mr. Baskin's claim if we don't have to have a causal relationship. The defendant, my friend Mr. Michaels, has cited a number of cases arguing for the contrary proposition, and respectfully, I think all of those actually were abrogated by Ford. I think they all invoke a causation test, and there isn't any test that's been proposed that isn't really just a causation test. Because what do we have? A causation test or a test that would only reach people like Ford, that wouldn't ever reach a custom home builder or a railway construction consultant. Because here, what does the defendant do? The defendant builds custom homes, and the defendant's argument that it's later work in Tennessee, and I guess theoretically it's earlier work in Alabama for Tennesseans, that those aren't related, that's strange. That's to say that custom home building isn't related to custom home building, which I submit that it is. I mean, it has to be. Otherwise, right, you're back to one of these alternatives: causation only, or Ford's the only person, the automobile manufacturers are the only people who are covered. On a note on temporal relatedness, we mentioned in our brief that this claim is not properly before the court, and it is waived, and it's also not the majority rule. Justice Kirby, I believe you asked when the claim, maybe it was you, Justice Lee. Justice Lee asked when did the claim accrue? And there's not enough information in the record to say. We say that the complaint pleads that the house was originally slated to be completed in January of 18. But it's very clear that that was bumped. There were ongoing negotiations. After that, the defendant's Tennessee contracting license application has already pushed, and that's in February of 18, says the house will be finished in May. So certainly by that time, the parties had already bumped out the completion date. And remember, this is a Rule 12 motion. We have to draw the inferences in favor of the plaintiff. And so, sure, it is conceivably possible that the plaintiff's claim accrued in January of 2018, but that's not an inference in favor of the plaintiff. It's an inference in favor of the defendant, because we don't actually allege specifically when the claim accrued or when the breach occurred. We just say what the initial understanding was, the initial representation. Chief Justice Page, you mentioned, and I think this is right, that many of these cases are hard, and they don't yield bright-line answers. And the Supreme Court of the United States has repeatedly been given the chance to give us bright-line answers, and it always refuses. In fact, I think this term, maybe this week, they were hearing a case on this topic again. I think it might be, was it on the temporal relatedness question? And the only thing we have is a rule of reasonableness. Is what we're doing here fair? Is it fair to require a defendant from Alabama who advertises in Tennessee, who does a lot of business repeatedly with Tennesseans, who applies for a Tennessee contracting license and registers to do business here, is it fair to require that person, that entity, to defend a lawsuit in Tennessee arising out of one of its contracts with a Tennessean? That's not unfair. That's not so outrageous we can't tolerate it in a civilized society. It's not beyond the pale. And
Is that the standard? Can't tolerate it in a civilized society?
well, that terminology is used in some 14th Amendment cases. I don't think the court has gone quite that far in these cases.
Just checking.
I think we could draw the line a lot farther back, right? It's not unfair under the case law. I think we could draw the line a lot farther back. So, for those reasons, Your Honors, we submit that the court should affirm. The only thing the court really needs to do is clarify its holding in Crouch that there isn't a strict causation requirement pursuant to Ford Motor Company, and it should affirm. Unless the court has other questions, I'm finished.
Thank you, Mr. Krogh.
You're very welcome, Your Honor.
Mr. Michaels, I believe you have 15 minutes. We don't require that you use all of it.
Thank you, and no, I do not expect using all of the 15 minutes. Going back to a few of the things that were discussed by counsel for Roger Baskin, as to the invoices being sufficient to confer jurisdiction, generally when you're looking at invoices, you're paying money to a foreign state and there's a product going back to the jurisdiction where the payment came from. In this case, there was no product. I mean, the payment would go from Tennessee to Alabama, but everything still remained in Alabama. There was nothing going back to Tennessee, which distinguishes this from those cases where invoices were relied upon, because generally there was a product going back to where the payment came from. As to when the cause of action occurred, even giving the benefit of the doubt that it wasn't in January of 2018, plaintiff still alleged that he incurred 3 years of storage costs, and he alleged that in September 2020. So that goes back to September 2017. So that's part of the plaintiff's claim. And just because Pierce thought the contract was continuing through March of 2018, doesn't mean that Baskin thought the cause of action was considering to March of 2018. And again, all Baskin says is they didn't complete it timely, and it was supposed to be completed in January of 2018. And generally, as opposed to the one long contract, as opposed to multiple small, I guess, actions under one contract, or one action under a contract as opposed to one contract with multiple small interactions. The issue there, again, Calphalon states that once you reach out beyond one state and create a continuing relationship and obligations with another state, then you're subject to regulations as a consequence of your actions in that state. Again, Pierce didn't create any continuing relationships with Tennessee in this case. Baskin certainly did create continuing obligations in Alabama. He was having his home built there. And absent any questions, that's all I have. Thank you.
Thank you. I believe that completes the docket this afternoon. May adjourn.
All right.